What I've done. I apologise that I was hoping, because I was here, that there would be some wonderful programme whereby if I put up a slide in English, it would automatically translate into Welsh by some sort of Google system, but unfortunately not, so I apologise to the Welsh speakers. I apologise too that all the Law Commission's publications on this project are in fact being issued both in England, English and Welsh, but all the Welsh translation is being done by the translators who do all the translation for the court services. We don't have any quality control. Oops. There's that. And therefore, I can't guarantee that the Welsh version is an accurate representation. But that does, however, highlight the problems that we do have as in a country known as England and Wales, where we have a single planning system that operates quite differently on either side of the border. If you have a system that purports to be a Welsh system, but is really an English system, it's not just the translation of the language, it's also the translation of the culture and everything else. But so, first of all, who is the Law Commission and why am I here? Why are we all here? The Law Commission is an independent statutory body set up about 50 years ago, and its role is to keep the law in Wales and England under review and to promote the reform, simplification and modernisation of the law. So from time to time it is invited to look at various topics. It might be the law on elections or the law on criminal sentencing or the law on level crossings or whatever. And it looks at it and says, actually, the law's in a complete shambles, and can we sort it out? And most, but not all, of its recommendations have been implemented. There was, for example, a large project a few years ago on the law of compulsory purchase, which was not proceeded with, I think because nobody in government actually has ever been able to understand the law of compulsory purchase. And currently, we're on a 12th programme of law reform, and we're just about to start a 13th programme. This project was proposed by the Welsh Government as one of two projects on the law in Wales, one was about making law, the formal accessibility of law in Wales generally, because suddenly you have a new legislative body, the Assembly, which can make law. And how should it do it? Should it just simply be a clone of Westminster, or should it do it differently and, of course, better? And how should that work? How does it deal with law that already exists, but which notionally applies to England and Wales? The other day, I was doing the last case before I left the bar, and I was doing a case in London. It happened to be about the education funding law, doesn't matter. And it was only after a few minutes I suddenly realised that we were all looking at the version of the School Standards and Framework Act that applies in Wales. And there we were looking at it in connection with a case in London. So even English lawyers find it, to be honest, a menace having the Welsh law sort of worked in with the English law. It would actually help everybody, both in England and in Wales, but of course especially in Wales, if we can start to disentangle. If we are serious about devolution, we've got to actually have a system of law that is a grown-up system of law that isn't simply just the occasional clause that says here or there, oh, and in Wales we do it differently. We've actually got to have a better system of law that is distinctively Welsh. So we've got a review going on. The stage one, we produced a scoping paper, came out this summer. Originally, when the project started, the intention was to actually improve the substance of the law. And the Commission talked, or I think at that stage, my predecessors, the Commission, talked to all the stakeholders in the Welsh planning community, and a lot of them said, well, we don't actually need to improve the system over and above what the Assembly is doing anyway as a political thing in the Planning Wales Act, Historically Barren Wales Act, the Future Generations Act and so on. And what we really need to do is to, taking account of those politically motivated changes, is to sort out the resulting text. because every time the politicians improve it, of course, it makes it more complicated. And you can tell that because if you look at the Planning Wales Act, it tends to say things like, after section 61ZB, insert section 61ZC, and then you know that you're in a muddle. The whole system is just simply a shambles. And so we reformulated the project so that it became a project to not any longer to improve the substance of the law, but to simply tidy it up, consolidate it, and make it better presented and more understandable, both by those who operate it, there's a lot of people represented in this room, and also the users, those who but the actual real people out there. And so we produced a scoping paper, and we have the summary, English and Welsh obviously, and also the main scoping paper. They're both available on the Law Commission's website. If you Google Planning Law Wales, you'll get there. We are asking for views on the scoping paper as to whether people approve the project in principle. Have we got the extent of the project, the scope of the project right, and also as to particular matters they want to see included. We're aiming to produce a full consultation paper with our full proposals in spring 2017, whatever spring is, and then a report to Welsh Government by the end of 2017. And the hope is that the result will be in the form of new legislation that will replace all the existing legislation in the field in probably 2020. The background into this is that planning law in Wales is fragmented, complex and difficult to understand. Since 2000 there have been 6 acts of the London Parliament and 4 acts of the Assembly here in Cardiff amending the Planning Act and so forth. It's quite difficult to determine whether amendments made to existing legislation apply in England or Wales, or England and Wales, or they apply in England and Wales but haven't yet been brought into force in England, and so on. So there is a concept which I must admit I was only sort of fairly dimly aware of until recently, that an Act of Parliament, that is to say an Act of the UK Parliament, extends to England and Wales, usually, i.e. not Scotland, not Northern Ireland, but it only applies in England or in Wales or in national parks or in London or whatever. This is a nicety which actually most people, it goes completely over their head, totally understandable, it went over mine. And so you tend to find, it says at the end, extends to England and Wales, and you think, oh yes, that extends to England and Wales. Well, technically it does. What that means is if you're done for an offence that you committed in Abergavenny, you can be done in the Hereford Magistrates, or vice versa, because it's one system of law that applies in England and Wales. However, it may only apply one side of the border or the other. That is a nonsense. It's incomprehensible to real people. And if it's incomprehensible to professionals, it's certainly incomprehensible to anybody else. So what we need to do is have a much simpler system and make it absolutely clear. You find that the Localism Act, for example, it's got all sorts of stuff about neighbourhood plans, but it extends to England and Wales. But wait a minute, it says a local planning authority in England may do this, that and the other. It says nothing about a local planning authority in Wales. So it extends to England, but it doesn't apply in Wales. That's kind of not immediately obvious. And there's almost all legislation in the last few years from Westminster has extended to Wales, but has not applied in Wales. So most of the Planning Act 2008, the planning, the main planning changes didn't apply in Wales. Obviously, the development consent stuff did, but all of the changes to the routine planning system didn't. But some bits did. But then the Planning Act also introduced, for example, some changes to the tree preservation legislation that do both extend to Wales and apply in Wales, but they haven't actually made regulations in Wales bringing them in, so it doesn't have yet been brought into force in Wales. Are you with me so far? This is all really rather tiresome, and if it's tiresome for people like me, goodness knows what it is for real people. So what we're trying to do is we produce a scoping paper which sets out our thinking, and we want everybody's views. And what we really want is to produce a planning code for Wales, and how we go about that. We want to produce technical adjustments where necessary to produce a satisfactory consolidated text, simplify the procedure and process as far as we can without actually making substantive changes, just make it more accessible and understandable, and also possibly put into the statute propositions of law that come from case law, which, quotes, everybody knows, unquote, but which actually ought to be on the face of the statute. There are at present more than 48 pieces of primary legislation. There are about 64 all told, but some of those are almost entirely repealed ones. I mean, are you aware that, for example, the Town Council Planning Act 1958 is still in force? 58. The answer is, well, yes, but only 2 sections of it. But of course, the worry is if you've got obsolete stuff like that, you sort of sit there going, but do I need to worry about those 2 sections? Answer, no, you don't. But there are also quite a lot of sort of semi-obsolete stuff that are there. And as I say, the devolution has made it more complicated, and we also want to try and make a balance between primary and secondary legislation. And because at the moment you have some things are in the body of the Act, some things are in schedules to the Act, some things are in regulations, some things are in schedules to the regulations, some things are in ministerial directions made under powers in the Act or the regulations. Which is where is actually pretty difficult to find, and there's no logic to it at all. Sometimes you find when politicians get excited about something, they create some new body, and you'll find in the actual substance of the Act, it tells you exactly how many members there must be of which committee, which is ridiculous. At other times, poor old Natural Resources Wales, for example, was set up by a statutory instrument under the Public Bodies Act. And so there is no act setting up Natural Resources Wales, but that statutory instrument amended primary legislation. So it's all a bit of a mess, but hopefully we can get that right too. We want to produce clarity and consistency. We don't want to introduce policy change. You've had enough of that. The politicians have sorted that all out in the recent legislation. But what we do need to do is to have clarity and sort out discrepancies. Why are some time limits 28 days, while some are 31 days? And let's have a standard thing, and let's find out when it says there's a time limit of 28 days, the clue is possibly in the multiple of 7. Does that mean 28 working days, and then what about bank holidays, or does it mean 28 days as in kind of 4 weeks? And anyway, when is the beginning? Is it the beginning of the day, the end of the day? All that sort of thing can be sorted out once and for all, and then applies throughout all legislation. This is what a day is, this is how you count it, that's it. Stop fussing. Frequently it doesn't actually matter what 28 days means, provided everybody knows what it means. It matters crucially to the people involved, case by case, but we only need to set that sort of thing out once. So let's have consistency and clarity. Let's get rid of the obsolete stuff that is no longer used. There's a lot of stuff that has been introduced but was never commenced, and there's provisions which don't reflect established pattern. For example, planning inquiry commissions. How many planning inquiry commissions have there been? They are there in section 101 of the Planning Act 1990, which was brought forward from the old 71 Act, for those who remember that. There has never been a planning inquiry commission anywhere, ever, either in England or Wales. But you wouldn't know that from the Act. Let's get rid of it. It's not needed. And in practice, of course, what the purpose of that is now dealt with by the development consent regime and the NSEP regime under the new legislation. So we get rid of planning inquiry commissions. A further one, which is perhaps possibly more controversial, although I think in reality perhaps not, if you have planning commissions operates alongside other statutory consent regimes, it may be that one could unify those consent regimes to make it a lot simpler. Sometimes that may be sensible, other times it may be not sensible. Ones particularly to think about are listed buildings, conservation areas and advertisements. Clearly we've got to make sure that right up front there is protection for historic assets, and I'm conscious I've got Caillou coming on next behind me this morning, and they will doubtless tell me it's all their rubbish. But in fact, it is already odd that the duties of conservation areas apply to all functions under the Planning Act. The duties relating to listed buildings apply only to determining planning applications. The duties relating to scheduled monuments don't exist because there aren't any such duties. And World Heritage Sites aren't in the legislation anywhere. And so, query, do we need to sort of sort that out a bit? But in particular, if you need doing works for a listed building, you are probably going to need both planning permission and listed building consent. I'd be interested to know if anybody here has ever come across a case where they've granted listed building consent and not planning permission, or vice versa. And in other words, you probably get to or refuse to. Do you actually need two applications, 2 consents, 2 committee reports, 2 decision notices, 2 appeals, 2 enforcement notices, and 2 appeal decisions and 2 cost decisions? If you just had 1 consent, all you've got to do is to alter the definition of development to include works to alter or extend a listed building in any manner which affects its character, etc. And then you automatically include all of the work which currently need listed building consent. And the policy duties could all be, they all apply anyway, but in fact could be widened to make it abundantly clear that they apply to all legislation. So that may be something that wouldn't in reality change the situation, but obviously I can see presentationally it might. Advertisements on the other, and conservation areas, interestingly, they have abolished conservation area consent in England in the Enterprise and Regulatory Reform Act, but not in Wales, in the Historic Environment Wales Act. But in reflection of just that principle. Advertisement consent, on the other hand, the vast majority of advertisements are actually things freestanding roadside hoardings, and probably aren't going to benefit hugely from a merging of planning and advertisement consent, I think. But I'm open to persuasion on that one. The Republic of Ireland, for example, they simply say that advertising needs planning permission, and then they have permitted development classes for advertisements exactly the same way as you have deemed consent classes in England and Wales. So that's the way to do it in Ireland. I'd be interested to know whether people think that would be helpful or not. I tend to think it probably it's easier being left as a freestanding code. Interesting that listed buildings are in a separate legislative code under primary legislation. Adverts are in a completely separate secondary legislation code. Trees are in something of a hybrid, and they're all over the place. So we need to think that out. Case law is a critical one. What's the story about case law? There are a lot of definitions which have been tweaked and fiddled with by the courts over the years, and things which could be on the face of the statute, and where all practitioners know what it means, but others don't. For example, what is the definition of a curtilage of a dwelling house, which turns up in various places in planning legislation? Is that something that ought to be put on the face of the Act, and if so, what would be the definition of curtilage? Or do you simply say, in determining the curtilage, you must have regard to certain things, or what? I mean, how would you actually deal with that? It's an easy one to see the problem, but I'm not sure I'm quite clear yet as to the solution. Conversely, there are other things, though, that whatever curtilage means, the case law is quite clear that if you are looking at what is the extent of a listed building, you look at what was in the curtilage of that building when it was listed in 1963 or whatever it was. If, on the other hand, you're looking for the rights of permitted development, you can do certain things in the curtilage of a dwelling house. That refers to the curtilage now, as at the date you're actually looking at it. Query, is that a sensible rule? But it again should be made clear, because that would be easy to put on the legislation. Curtilage means the curtilage at the time you're actually looking at it, or the time that the building was listed. And anyway, what happened if the listing was subsequently upgraded? Does that change the curtilage? So there are certain sort of things. This is not policy change. It's just simply making it clear. In many cases, it doesn't matter what the rule is particularly, other than what does matter is that we know what the rule is. Oops, sorry, wrong way. What might be the eventual structure? What we hope to do is to replace the existing mess with perhaps something like 6 acts in the long run, and at the moment we're focusing on the first 3. Planning Wales Act, Management of Development Wales Act, Regeneration Wales Act, the names will no doubt come out looking something different, but something along those lines. And then in the looking further ahead, Historic Environment Wales Act, Natural Environment Wales Act, and the Access and Rights of Way Wales Act. So the first phase, the Planning Wales Act, would include the general principles. We heard just now about how the Minister wants joined up planning. There are lots of general principles applying to planning. Some of them, a few of them, are actually in the Planning Act. You must have regard to the development plan and all other material considerations. Everyone knows that. You were told that with your mother's milk. But the requirement to give primacy to the development plan is, of course, as you'd expect in the Planning and Compulsory Purchase Act, Section 38(6). Oh, weird place to find that. But the requirement to have regard to sustainable development used to be in the Planning and Compulsory Purchase Act, but that, of course, only applied to making development plans, and now, of course, is in the Future Generations Act. So that needs to be brought right up front. Those are the easy ones. But what about the duty to be nice to listed buildings, which is in the Listed Buildings Act, the duty to be nice to national parks, which is in the National Park legislation, the duty to be nice to AONBs, SSSIs, which are all in the relevant other legislation. What about the duty to have due regard, not special regard or pay special attention, but have due regard to the desirability of eliminating unlawful discrimination to protected minorities under the Equalities Act, which applies to all public authorities, but clearly that's highly relevant to planning. What about the duties, and that of course is in the Equalities Act, Section 48, which of course you're all familiar with, and remember all the time. What about the duty to have regard to the countryside in carrying out any function under any statute relating to the countryside, land in the countryside? Any public authority shall have regard to the desirability of preserving and enhancing the countryside. You will tell me where that is? Yes, of course, it's in Section 12 of the Countryside Act 1968, which of course you all know. But I mean, why is it there? And how many people actually give any attendance to it at all? We know about the duties on conservation areas because there's been litigation. But the duty about the Countryside Act, it's there, but totally sort of dormant. And what about the duty under the Criminal Courts and Criminal Justice Act, or something? It isn't quite that, but it's something like that, which says that in carrying out any function under any statute, any public authority shall have regard to the desirability of reducing crime and preventing the outbreak of further crime. Familiar with that one? Probably not. Now, all that needs to be either brought into the Planning Act right at the front, or possibly have signpost provisions saying you must also have regard to the duty under whatever section of whichever act, so that we can actually see what's going on. So, the general principles, I think, is crucially important. So that planning, those administering the system know what it is that's on their sort of list of things to think about. Those on the receiving end know on what basis the whole system is being administered. And then, of course, at the end, you've got other material considerations. Everybody always forgets about the other material considerations. There may be all sorts of other material considerations that don't happen to be in any statute, but that needs to be really made clear. So we need to sort of see how do you balance all those duties together. Planning authorities, actually, the law on planning authorities is actually very simple in Wales. There is only one chair of local authority, and it's either that or a national park authority, and that's it. But gosh, look at the pages of the encyclopedia on what is the planning authority. Completely unnecessary. That could be hugely simplified. The development plan system, we've of course now all simplified in Wales because of the Planning Wales Act. Once it's been brought into force, fully brought into force, and that just needs to be restated. We don't want to go tinker with that again. Whether for better or worse, from my perspective, I'm assuming that the politicians got that right. You may disagree, but that's not for me. But I think we need to get it clear and in one place, so we don't have to sort of have a paper chase to find it all. Applications for special cases, Crown, statutory undertakers, and so local authority land, and so on. Have that right at the beginning and say these provisions apply to all planning code, and the definitions. Just have one set of definitions that apply to everything, and then you know where you are. Then you go to the Management of Development Wales Act, or do we call it what used to be known as Development Control when I was brought up, but is now I think management because that somehow makes it feel better. And also that would no doubt become Modoir, which probably sounds better than Codwar. But the need for planning permission, how you make applications, how you grant permission, appeals, purchase notices, right notices, revocation, unauthorised development. In other words, that whole sequence of events which we all know, but which are slightly all over the place at the moment, but and they've been hugely altered over the years. That's probably largely a tidying up job, but there may be a certain amount of case law to be inserted there in appropriate places. The need for planning permission in particular is important. That needs to be clarified a lot, because that one section, section 55, is hugely overloaded with stuff. And I think probably could be separated out into a number of bits to make it clearer. On the other hand, the purchase notices, blight notices and revocation procedure, you probably just have one section in the main bit of the Act saying there is a thing called a purchase notice and a blight notice and revocation, and then all the details that are in the schedule out of the way. How many people here have actually had a blight notice? How often they happen? Not, I would guess, probably very often. I mean, no doubt one or two here or there. But having it all on the Act makes it look far more complicated, when in reality, blight notices are once in the blue moon. When did anybody last revoke a planning permission? Doesn't happen, or discontinue a planning permission? It doesn't happen very often. So let's try and make the Act, the shape of the Act, actually work better for practitioners and real people. So the things you actually need to see all the time, the definition development, is clear, maybe in several sections. The things you don't need to see all the time, like the procedures on revocation orders, can be in a remote schedule out of the way, and so you can forget about it. It's there, and you've got to have it, because you have to have a procedure for revoking planning permission, but frankly you don't often use it, because of obviously the compensation. Looking further ahead, regeneration, there's quite a number of powers all over the place, which probably need to be sort of thought through, which ones we really need. The powers of the Welsh ministers are, as you would expect, largely in the Welsh Development Agency Act. And the Welsh Development Agency, of course, ceased to exist some while ago, but the Act has been heavily amended so that it now refers to the Welsh ministers. The enterprise zone regime, that does still apply. Derelict land provisions do, at least in theory, still actually get used. New towns, on the other hand, there's only been one in Wales, designated in 1948, scrapped in mid-1980s, and the winding up arrangements have now long since ceased to apply. So do we really need the New Towns Act and all its various regulations and all the special things that say, oh, in a new town you must do this, that and the other? Probably you could actually just scrap the New Towns regime. If there are bits of the New Towns regime, like the special compensation provisions or so, that are used in other contexts, let's fish them out of that and put them where they belong. Urban development corporations, there's only ever been one in Wales, Cardiff Bay, and its powers long since been transferred elsewhere, and that's now a complete dead letter. Do we really need those provisions? Is anybody going to have a newer UDC? And it's noticeable that in Wales, the UDCs actually have different powers anyway from those in England, curiously. Simplified planning zones, I don't know of any in Wales. There may be some somewhere. I'd like to hear if there are. I've heard only this morning rather, about they do exist in Slough, which I don't think is in Wales, and you go through it on the way there, but SPZs, I noticed that certainly in new national policy, they hardly get a single mention. The new English policy, NPPF and the planning guidance that there is not a single mention of simplified planning zones. I suspect the same is true in Wales. Housing action trusts, again, totally defunct now. Do we need them? Can we just scrap them? Or certainly can we scrap them as planning authorities? So we can just unhook them from the planning legislation. And rural development corporations, I'm offering quite a large prize to anybody who can tell me under which piece of legislation you would find it. And just as a clue, it's the Agriculture Act 1967. And there never has been one in Wales. There was one in England, which was abolished after about 1 year, back in the late 60s, scrapping. Or do we need them? I mean, if you think we need them, tell us. But a lot of those bits of legislation are just simply redundant. One can see, looking further ahead, that one might extend to say, a historic environment, consolidation to include the powers of CADU, explicitly World Heritage Site, ancient monopolistic buildings, conservation areas, parks, gardens, grasslands, and repairs. That would be one possible further link. But again, you don't need to repeat all the definitions because that just be part of the planning code. Ditto and Natural Environment Wales Act, maybe. Natural Resources Wales, National Park, Testing Society, OEBs, and so on. And forestry, trees, and hedgerows. And then finally, an access and rights of way. Picking up public rights of way, village greens, and access land. So you've got, that will give you a full sort of thing of 6 manageable sized, sensibly organised bits of legislation. And instead, what you repeal, nearly there, is you repeal all those acts which apply only in Wales, the Welsh Development Act and so on, and much more important is the Planning Act, the Planning Wales Act, the Historic Environment Wales Act. You would also repeal all this legislation as it applies in Wales, and all that legislation also as well, all that goes. So all those favourites that you've used all the time, all disappear, and all part of another 21 acts, which are either more or less obsolete, but not quite. So that's the prize, to get rid of all that junk, to make it really simple, to make it really straightforward. So what do we want? What we want is, what the Commission we want is comments on the scoping paper, please. Have we got it right in principle? Does anybody have any comments in detail? What topics should be included, particularly what areas of law? What existing law is redundant or is not redundant? It might look as if, but it isn't. What case law should be codified and included? And then we have to say we have a full concentration paper in spring next year, and I'd like the input from you all into that process, and send it to me at the Law Commission, or Charles Mynors at Law Commission, or whatever. I'm sure you'll find me somehow. And I would really like to hear from you. Thank you very much.